After a whirlwind week of Supreme Court rulings, more big decisions are coming down this week as soon as tomorrow. First, Obamacare survived its third major challenge since its inception in 2010, as the court agreed to leave it in place in a 7-2 decision. The court also sided unanimously with a Catholic group in Philadelphia that declined to consider same-sex couples as foster parents, prompting more tests to come where the First Amendment's protection of religious freedom can come into conflict against LGBTQ policies. Of the decisions expected this week, the most pressing case is coming out of Arizona. In a case that's focused on Section 2 of the Voting Rights Act at a time where there are hundreds of active efforts led by Republicans to restrict voting rights in nearly all 50 states. The court will decide whether restrictions on voting in the wrong precinct and ballot collection disproportionately hurt voters of color and violate federal law. With me now is Katie Barlow. She's a lawyer and a media editor for the SCOTUS blog. Welcome, Katie. The Arizona case is a huge case regarding voting rights. Talk to us a bit about the implications of this ruling and what it could mean to all of us nationally.
Well, as you said, Michael, this case is about two Arizona voting provisions that come to the court by way of these two provisions. One that outlaws ballot harvesting, the collection of ballots by third parties, and one that basically requires electioneers to throw out any ballots that are cast out of precincts. But the second and the most important part of this case is it gives the court an opportunity to clarify the test for Section 2 of the Voting Rights Act. And what Section 2 does is it bans discrimination on the basis of race in voting. And as you know, how they decide this test is written can strengthen or weaken Section 2 of the Voting Rights Act. And as you may recall, in 2013, the Supreme Court effectively gutted Section 5 of the Voting Rights Act, which required certain jurisdictions, largely in the South, to get pre-approval before they changed their election processes. So this Section 2 now coming before the court is the same similar setup of how they will write the test that could strengthen or weaken that provision of the law. And again, as you know, we have seen the GOP in over 33 states across the country introduce legislation restricting voting on same day, mail-in, absentee ballots. And so how the court clarifies this test will also affect those pieces of legislation that have been introduced and passed across the country.
And clearly there is anticipated potential impact the decision could have on voters of color. From the decisions we have gotten so far, read the tea leaves for us. How is this new conservative leaning court approaching its decision making in cases like this?
Well, I'll tell you from listening to the oral arguments that were remote this year, so we had to listen to them and we couldn't be there in person. It appeared from reading the tea leaves that the Supreme Court was inclined to uphold these two provisions of the Arizona law and in some way uphold and not gut Section 2 of the Voting Rights Act. What was less clear was precisely how they were going to do that. The court was really grappling during oral argument with what these restrictions meant and whether the test was going to be, is the end result that it just has the effect of discriminating on the basis of race, or do we need to also look at intent? And is that part of the calculus and the test for striking down laws that would be prohibited under Section 2? They were really grappling there, and there's no way to read the tea leaves exactly how they'll come out. But it seems clear, at least from oral arguments, that they're likely to uphold Section 2 and not gut it in the same way as Section 5. But you never know.
Yeah. So, Katie, as you know, the Supreme Court has been in the crosshairs in more than one way. There's been a push by progressive Democrats for Justice Stephen Breyer to retire. Let's take a listen to some of that.
There is no question that Justice Breyer, for whom I have great respect, should retire at the end of this term. I mean, my goodness, have we not learned our lesson?
You're asking me this question, so I would give more thought to it, but I'm inclined to say yes.
My recommendation would be the same as Representative Jones and Alexandria Ocasio-Cortez, which is that I do believe that he should retire prior to the midterms. I think that would be best for our country.
So just very quickly, this would give Biden an opportunity to fill the seat with a woman of color, a campaign promise of his. But Senate Majority Leader McConnell is warning Republicans would block nominees if Biden gets a chance to appoint someone. Can you give us a sense of how Breyer is handling this pressure right now? And what can we expect from that kind of pressure on the court?
Justice Breyer has several times in public recently in giving speeches in Harvard and perhaps in his book that is forthcoming in September, has talked about the over-politicization of the court and talking about the presidents who appointed the justices rather than the justices themselves and how they apply the law, suggesting that this kind of talk and this kind of pressure on the court will have a negative short-term and long-term effect. So it seems to be Justice Breyer pushing back on this pressure and this idea that they make these decisions politically. Now, of course, on the other side, and to your point in the previous commentary, the left side of the party is certainly interested in him stepping down and perhaps replacing him with somebody younger like Judge Ketanji Brown Jackson, who was just appointed to the D.C. Circuit and confirmed and sworn in this week. But reading the tea leaves on Justice Breyer's possible retirement, it seems unlikely at this point, but we'll see.
Katie, I appreciate you. Thank you so much for joining us tonight.